It's time now for a chat with Pat.
Yes, and today we have with us Andrea, I think it's Picciotti-Bayer. She is a legal analyst for EWTN News and director of the Conscience Project, and she wrote an article in National Catholic Register called Louisiana and Texas Courts Don't Get the Ten Commandments. Good morning, Andrea. How are you today?
I'm doing great, Pat. Thanks for having me on.
Yeah, this article, I think, because a lot of people just thought, yep, this is a done deal. Louisiana and Texas can display the Ten Commandments, but something happened. So can you explain kind of what the laws were? They alike? Were the laws alike in both of those states? And then what happened that this got nixed right now?
Yeah, no, great. Thank you. So the laws are very similar with some differences, but in general, both laws require the passive display of the Ten Commandments in public school classrooms in the states. Okay. And basically, by meaning passive displays, it's just hanging up on the wall, visible and of a certain typeface and that sort of thing, but students aren't required to recite them, to read them, to be tested on them. Teachers aren't required to, opine on them or analyze them. They're just there for students to kind of contemplate, an invitation, let's say, as opposed to an imposition. And so, of course, all good things are likely to trigger a lawsuit. And lawsuits were brought in federal court against the laws in both Louisiana and Texas. Residents were represented by the ACLU, who originally were founded to defend civil liberties, including religious freedom, and they claimed that it was a violation of both religion clauses of the First Amendment, the Establishment Clause and the Free Exercise Clause. Oh. So far, the lower courts have agreed with the ACLU, but I think, especially in papers that I filed in the Fifth Circuit in defense of the Louisiana law, I really do think the Constitution permits these displays, but it is going to be a little challenge because there's some old law on the books that the Supreme Court or the Fifth Circuit really need to say no longer applies, and making it very clear that it's completely constitutional to have these laws in place.
Can you give us a little taste of those old laws that are causing problems here?
Yeah, one is like specifically on point, and it's called Stone versus Graham, and it deals with a similar law mandating the display of the Ten Commandments in Kentucky in classrooms. The challenge here isn't that we're just getting rid of a law, a decision we don't like. That decision, Stone versus Graham, rested on kind of the Supreme Court's misunderstanding of the Establishment Clause and a case called Lemon, the Lemon test on how to figure out whether something violated the Establishment Clause or not. In practice, Lemon was used really kind of weaponized against religion so that any religious displays were deemed unconstitutional. The Supreme Court, especially this Supreme Court, Pat, which is just incredible when it comes to religious freedom, has clarified what the Establishment Clause really is about in light of the founders' intentions. And it's clear in light of the history and tradition of displaying religion and even the Ten Commandments in public places, that this kind of passive display, again, isn't a violation of the Establishment Clause.
Yeah, it amazes me because people always say, oh, you can't post these things, and I'm thinking, no, that the Establishment Clause basically just says they can't establish a religion that we all have to kind of be a part of, So that's why I like it when you talk about passive displays. I think that's so important for us to get through our heads.
Yeah, and it's very important that we understand that these old precedents kind of had a shag carpet understanding of the Establishment Clause. They were kind of fixed in the 70s and the 80s, if you can remember what your basement carpet looked like. And instead, now we have the benefit of great scholarship that's come out, really helping us better understand what the founders meant at the time and what the First Amendment is there to protect. And really, it's a check on the government. It's the government not getting into the inner workings of a church, and it's the government not imposing a religion on the people. But it's really ironic, Pat. You can see even in the Supreme Court frieze, you see Moses and the Ten Commandments. So
Yes.
even in our nation's highest court, they don't seem to be bothered by the
Yeah.
fact that there's a religious tradition to the founding of America.
Mm-hmm. Yeah. That's the thing that always amazes me, that when you go to Washington, you see this stuff all around, and nobody's saying take it down. So where do we stand now, Andrea, with this whole thing?
So it's really kind of interesting for any of the lawyers listening. They're going to be fascinated by this. Right now, the lawyers helping to represent the state of Louisiana, which includes not only their Solicitor General's office, but also an Attorney General's office, but the Beckett Fund for Religious Liberty, they've asked the Fifth Circuit Court of Appeals, sitting en banc, which means the entire court, to review the Louisiana case. The AG from Texas has appealed the Texas case as well. It could be that this is resolved by the full Fifth Circuit, not just a 3-judge panel. Or it could be that it's going to need to go to the Supreme Court. And I tell you, in light of recent cases, I think the court is going to take seriously the issue and hopefully conclude, as I believe they should, that it's completely constitutional, these laws are.
So, Andrea, why... I know we've got these old laws on the book that seem to be kind of messing up things, or interpretations of them. But you say the Supreme Court's been fairly clear. Is it that they just haven't been clear enough that these lower courts keep going back to these old laws?
Yes. And part of it in deference to the courts, a lower court can't overrule a Supreme Court decision, right? And that's just the way that we have things set up, the respect for prior decisions, for precedent. So it is delicate. It's a little bit of a dance that we're dealing here. But it is clear that in this case, it's a great reflection of the evolution of the Supreme Court's religious freedom jurisprudence and how it's coming more and more in line with an original understanding of the First Amendment. It's difficult, it's bumpy, but I do think that we're heading in the right direction. And it's another reflection that people are recognizing that our young people do need to have something to hold on to, and a deep, rich respect for our history, even including our religious history, is a part of that.
Yeah, and it seems that these are formation years, and so they're being formed in something. So if you don't use the Ten Commandments, what are they actually being formed in, right?
Absolutely.
Yeah. Well, Andrea, this was great. You always give us such clear and concise looks at these issues. And can you tell us, when do we expect to maybe have this ironed out?
I would say first pray. A decision from the Fifth Circuit's going to be coming on whether they're going to review Louisiana's case any day now. And if not, it could be brought to the Supreme Court this term.
Okay. Well, thank you so much, Andrea. Our guest today is Andrea Picciotti-Bayer. She is the legal analyst for EWTN News and director of the Conscience Project. Have a good weekend, Andrea.
Thanks, Pat. You too.